Section 5 of the FTC Act, as you know, has two dimensions. One deals with unfair methods of competition, the other with unfair or deceptive acts or practices. I'm going to go through how the framework on both sides of the agency's jurisdiction might be applied to the misappropriation of intellectual property and its use as a means of developing or expanding business for firms that don't pay or license to use the intellectual property properly. Without trying to define the complete framework of Section 5 or to deal with some of the more difficult questions about its broader scope or what the limiting principles might be, I think it's helpful to think about how we could apply some very basic screens in the application of the statute to decide how piracy might be treated. I think the first and broad area of consensus is that Section 5 as a distinctive theory of liability should apply to episodes of serious misconduct. And it seems to me that piracy at issue here easily clears that threshold, both with respect to the original conception of the statute, to its application in the early decades of the FTC's operations, where in many instances misappropriation of intellectual property rights featured prominently in FTC cases. That is, if we think about the fidelity of a theory of liability to original conceptions of what the statute might reach, unmistakably, privacy-anchored cases would fit squarely within the view of Congress and the early commission about what the appropriate use of the statute would be. If we asked by reference to more modern conceptions of either economics or law how we address or respond to piracy, piracy is a serious form of harm, both with respect to actual economic effects and with respect to likely economic effects. It's very difficult to imagine that it would be necessary to spend a great deal of time to establish the case that this kind of behavior is serious misconduct. The second screen we would use is whether there are plausible justifications that can be brought to bear to rationalize the misappropriation of intellectual property. And it seems here that it's hard to muster good justifications for the behavior, indeed any justifications at all. In this instance, we avoid the messy questions of whether or not there are offsetting pro-competitive justifications. It's hard, I think, in any theory of law, competition law, property law, contract law, any framework that we might apply to muster a good justification for theft. It's very difficult to conceive of how it would be useful. I'm not talking about hazy instances in which we might have disputes about whether or not a license covers a specific use. I'm dealing with a simpler scenario of an outright simple theft of the property where the user knows with certainty that a license ought to be obtained and simply chooses not to do it. In this instance, it's hard to imagine a pro-competitive or beneficial justification for the conduct in question. So the second screen that I think these cases would pass through with relative ease is the application of a justification standard. Hard to see how those exist here. The third question might be the application of other legal frameworks. And here I think there are really two questions. Is there an existing concept in legal doctrine that might conceptually cover the behavior? Second, as applied in the routine decision of cases, the routine vindication of nominal legal rights, does the existing apparatus of enforcement provide another path? If you answered yes emphatically to both of these questions, then you might ask quite properly, why would the FTC be involved? I think the challenge to the FTC to be involved might be greater, perhaps for any public institution. What about existing doctrine? Well, there's little question that virtually all systems of law across the globe treat theft as a serious offense. So it's neither jarring or surprising that the theft of intellectual property might be regarded as a serious offense. The real question then becomes, what about the mechanisms for applying it? And I think in this instance, we find the absence of effective mechanisms of oversight and implementation in the jurisdictions in which the theft takes place, as well as the relative weakness of mechanisms in North America to use alternative strategies to challenge the behavior through through trade or other law that might be applied to the misappropriation of intellectual property. There's a legitimate question to ask: at what point do we look at a nominal legal framework and declare it to be inadequate or ineffective? And I think that is a legitimate point for discussion and debate, but it seems to me that in the context that we're examining now, that there's been a demonstrable failure of the nominal legal mechanisms that might be used to address this behavior. Either the public authorities in the relevant jurisdictions choose not to use them, or that companies that are victims of the conduct in other jurisdictions find it extremely difficult to vindicate their rights in the court. This is something that you would evaluate on a regular basis to see if changes have taken place to make the application of a nominal legal command effective over time. But if we ask in general, is there an effective framework for giving meaningful implementation to legal commands that forbid piracy? I think the answer, generally no, at this point is a confident no. A last hurdle to be cleared under the FTC Act, and here I think today we'll see some variation perhaps in the application of state laws. The prohibition on unfair methods of competition calls for harm to competition, some theory of competitive harm. And there it might be necessary as a matter of demonstrated anti-competitive effect or likely effect to show that the misappropriation injures rivals. That is, an apparel manufacturer that plays by the rules, pays for the rights in question, suffers a competitive disadvantage at the hands of a firm that does not. There, I think it would be adequate for FTC Act purposes to show actual or likely harm. And if we see the FTC framework as a series of interdependent elements where we demand proof or additional proof depending upon the conclusion we draw about the seriousness of the misconduct, serious misconduct, absence of justifications, hard to find them here, weakness in the nominal framework for implementation, decidedly weak, then we might be less demanding with respect to the precise quantum of actual or likely harm. For unfair deceptive acts or practices, the protected group consists of what the original FTC policy statement and the 1994 legislation that codifies it refer to as consumers. The formative FTC cases tended to focus on harm to individual end users. The famous Orchid case that dealt with pest control services, a unilateral increase in prices imposed by the service provider. In theory, individual consumers, under any well-accepted principle of contract law, could challenge that. It's a breach of contract to unilaterally increase the price. That's a fairly straightforward case. Why did the FTC intervene? Because the means available to consumers to vindicate their interests were decidedly weak. And the gap between the amount of individual harm, the benefit to the company, the cost to bring that case for an individual consumer or to join a class made, in practice, the vindication of those rights unlikely. But the victims were end users. So the tougher question comes up: what if the victims, the consumers, are commercial entities? The Commission has brought cases in which the victims were small businesses. The N-Data case, which deals with the repudiation of a previous promise with respect to IP licensing, is a famous example in which the FTC was willing to act under either an unfair method of competition theory or an unfair deceptive acts or practices theory to protect the interests of computer manufacturers. Dell, for example, being one of the major victims in the FTC's theory of liability. So the FTC certainly, through its own enforcement process, in settlements that have not directly been challenged through actual litigation, has achieved what might be called an expansion of the notion of the zone of protected interests, so that not necessary under that theory to show harm to a competitor or harm necessarily to an end user, but harm to other commercial parties has been deemed to be sufficient to establish the application of the Commission's jurisdiction. Future cases may litigate that point directly and ask whether or not commercial entities deserve protection within the FTC's conception of unfair deceptive acts or practices. That's probably the trickiest legal point going ahead. But when we look at the other screens that might be applied, seriousness of the misconduct, offsetting justifications, effectiveness of enforcement through other collateral mechanisms for legal review. It seems to me that you get by all of those screens relatively easily here. The one issue that might be interesting for debate, if the Commission were to use its authority here, would be the last one. That is, who constitute the zone of protected interests, whose interests are protected under unfair methods or unfair acts or deceptive practices. Thank you.
Well done. Let me address the letter that you referred to, Greg, and Bill, I'd like to ask you about it. As I recall, we sent that letter in about November of 2011. If I'm right about that, it arrived just after you left the FTC.
That was the golden age.
We missed our opportunity, clearly, the window. You could almost hear it slamming shut as you walked out the door. But no, in seriousness, we wrote a letter. There were two of us who put that letter together, Attorney General Jim Hood of Mississippi and myself, the reason being that we were the co-founders of the Intellectual Property Task Force at the National Association of AGs. And because we had more than 2/3 of the AGs sign it, it became official NAG policy or policy statement. And for any of you who are interested in reading that letter, it is found at the National Association of AG's website, nag.org. It should be posted there with other sign-on letters from 2011. And the letter basically asked the FTC to look at stolen IT as a matter of unfair practices, unfair trade practices under the FTC Act Section 5. In hopes that the FTC might seriously consider bringing an action under federal law of the type now that we've seen brought by some of the states. Do you have any thoughts about the likelihood that the FTC could bring some such action under FTC Act Section 5 in the future?
I think it is feasible. I think that there are some interesting questions of policy and technical analysis that would go into framing such a case. When you look at the DNA of the FTC and go back to its origins, as we mentioned earlier, business torts were a key component of the initial framework. The expectation that the FTC would establish national norms of business conduct by using this distinctive capability. And the idea that an informing vision for how to do that would come from well-established concepts of business torts was a central assumption on which the agency was created. So I think from a number of perspectives, that is going back to, again, original purposes, actual capabilities, this is the kind of matter that might well lend itself to the application of the FTC's authority. And you're familiar with the broader debate about Section 5. That is, what is the high ground for the FTC to pursue? Not just to use Section 5 of the FTC Act as an end in itself. Activity for its own sake is not an appropriate pursuit of public policy. Yet the use of this distinctive capacity to resolve legal concerns that escape appropriate resolution by other mechanisms is exactly in the conceptual sweet spot of what the Commission should be doing. And it seems to me that this is a very promising area for discussion and consideration by the agency. Again, serious misconduct, yes. Offsetting rationales, hard to find them. With a variety of effects that Emilio described before and that Tiffany referred to as well. I guess what interests me in part is that when you did the letter, were there conversations with the FTC before you wrote the letter?
I don't think that there were. I think we were focused on using state law at that time. If I were to do it over again, I probably would pursue that avenue as well.
I think in the framework I have in mind, that would be part of the conversation that happens before the group does the letter. And I think for purposes of thinking of how, again, if we envision this federal-state constellation of decision makers as fellow venturers, they're partners in a common enterprise. Both with respect to the federal statutes, but also to the distinctive supplemental capabilities that come from state law, that greater efforts to realize the full potential inherent in that framework would be a good way to take on this kind of issue too. And to talk about, as you said, I mean, the tough question that was posed before, how do How do you get jurisdiction? How do you get discovery? What happens if Embraer, notwithstanding all the concerns you mentioned, say, thank you for your interest in competition law? No. And as you mentioned, they have very good reasons to be concerned about the North American market and the whole RJET sector in which they're so important. But that's where you start engaging the national authorities that have some other instruments now that help address these kinds of issues. That in particular, where you have an overlay of foreign policy, you have an overlay of trade policy. I think by engaging this larger collection of resources, when you come to the tougher cases, you have a better platform for getting answers for a very serious economic problem.
Makes sense. Very good.
What do you think of Commissioner Wright's policy statement last week on the use and the limits of Section 5, and both generally and how it would apply to the kinds of issues that you've been discussing today?
First, for the purpose of moving the discussion within the FTC towards the development of a common set of standards, I think it's a great start. In its 100-year history, almost 100-year history, the Federal Trade Commission has never issued a statement, a policy statement that says this is what we see Section 5 to be with respect to unfair methods of competition. It's done that for unfairness. It's done that for deception. It's done that for merger policy. It's done that for competitor collaboration, but not for this ingredient of its authority that is integral to what it does. In my business in the university, to pass the course, you have to turn in a paper. It doesn't always have to be a great paper, but you have to turn in a paper. The FTC for this 100-year-long course has gotten incomplete because it's never written the paper. As a starting point for thinking about where we go ahead. So bravo to Commissioner Wright for stimulating that debate and setting things ahead. I think if we look at a couple of core elements of his theory, a couple of respects in which, again, the notion of how the misappropriation of IP fits within a possible conception of what Section 5 might involve. If you're taking the clearest cases, that is not more problematic cases, but the clearest cases, what's in the bullseye? Serious misconduct, no offsetting justifications, and the incapacity of other legal regimes to deal with it effectively, 1, 2, 3. I think that's what we've been talking about today. So, and I believe that Commissioner Wright had in mind, in particular, harmful conduct, no justifications. I believe if we just take those two critical screens that he applies, it seems to me that this fits.